We know that is potheads cannot possess firearms. That is the law, federal law, that says if you are an addict of unlawful substances or a user of unlawful substances, including cannabis, even though it's legal in many, many states, you cannot lawfully possess a firearm.
So, is it illegal or unlawful for you to own a firearm if you occasionally blaze up? That's the question we're going to answer today. So let's get straight on into it.
Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, this is an issue that I have taken personal interest in, maybe because I live in a state that has legalized cannabis, and despite the fact that our state is screwed up 6 ways to Sunday, it's actually not because of the legalized cannabis industry. No, and perhaps it's the fact that I really do strongly support personal choices, personal lifestyle choices, and I realize that there are many people around the country who have medical conditions that are actually managed by physicians through the use of medical cannabis, and yet now they have to have a choice between getting proper medical care or exercising what is supposed to be a God-given inalienable right. We even followed a lawsuit out of Florida filed by Nikki Fried, the agricultural secretary down there, challenging the prohibitions in federal law against what? Well, against those who use marijuana, cannabis, whatever you want to call it, from possessing or having in control a firearm or being able to purchase a firearm. It puts a squeeze on marijuana users. It puts a squeeze on the FFL industry. But maybe we need to have a new discussion about that in the post-Bruin world. Maybe we really need to have a discussion about that in the post-Rahimi world. And actually, maybe that discussion already happened and we've gotten a huge ruling out of a court that matters. So today, let's spend a few minutes and go get you up to speed on when marijuana users get the same rights as the rest of us. United States District Court for the Western District of Texas in beautiful El Paso, Texas. Now, what was initially challenged and then what was ultimately challenged on a kind of a do-over here are two separate statutes. One is 18 United States Code 922 Section G3. We know that is potheads cannot possess firearms. That is the law, federal law, that says if you are an addict of unlawful substances or a user of unlawful substances, including cannabis, even though it's legal in many, many states, you cannot lawfully possess a firearm.
So you guys see right off the rip confusion. At the federal level, it's still illegal, but at the state level, it may be legal. I think 34 states have medical, and I think 24 have recreational. My figures may be off. I'm going to double check, but you can see right there, there's a little bit of a confusion, and that can cause issues for people when they're trying to figure out what is the right thing and what is the wrong thing to do. So let's move on. The U.S. Law Shield actually breaks this down very well.
If I have a medical marijuana license, does that prevent me from being able to purchase or possess firearms? How does that work?
Yes.
And this is a little bit different because it's not just like you're recreationally using it. Right here, we're speaking about medical use. So if you got an issue, a medical issue, and it's been directed by a physician that you need to use some sort of medical cannabis, that can really help you out. But in this situation, is it actually running foul of the law, especially if you are a 2A advocate?
So this is one of the more complicated "it depends" answers you're going to hear from lawyers, because we don't really have great legal authority for you. So of course we have marijuana being illegal under federal law.
Right.
We've got it legal under some states' laws.
Yeah.
And that really puts your licensing status in a tough spot, because let's say you're in a state where marijuana is legal. You have a medical marijuana card. I'm just going to, we're here in Texas. We do not have legal marijuana, but let's call it Colorado.
Sure.
Right? So you've got that, you've got some sort of documentation that you are a lawful user of marijuana.
Right.
You would think the state of, let's say, and this is just hypothetical, Colorado, would say, okay, well, that's fine. That's just like, having a beer or a glass of wine every once in a while and also having a carry permit, no problem. The problem comes in that most states have a requirement when getting that carry license that you have to be otherwise qualified to purchase and possess firearms under federal law, right?
And they're reporting it to the feds in many of these states.
Exactly. So
if they're reporting to the feds, you definitely got to be careful that you don't line yourself up or set yourself up for trouble. So just keep that in mind.
Are you, number one, going to be not qualified to possess under federal law, which means you're already committing a crime if you've got that carry license carrying and you have your marijuana card.
Check the side eye.
Or potentially,
He's like, yeah, that's
you know,
risky.
is yours carrying
Check it again,
and
check it
you have
again.
your marijuana card. Or potentially,
He's like, yeah, don't do that.
Is your state going to say, well, we know that we say marijuana is legal.
Right.
However, you still can't get your carry license because
Right.
you have to be qualified under federal law as part of our state's law, and you're not.
Yeah.
Right?
No, it's a tough situation because I talk to clients who say, hey, I have a condition. I don't want to use hardcore narcotics, maybe CBD, maybe marijuana, maybe legally, illegally. And they don't want to sacrifice their Second Amendment rights because they found some alternative that they
Right.
find as a lesser of two evils. And it puts a lot of people in a really tough spot.
It does.
That's a really important point, and shout out to my homie for raising that point on that video. But what he is saying is that there are a lot of hard drugs, a lot of pharmaceutical drugs that have really negative side effects, and they really are just super expensive. They cost a lot. So a lot of people who do not have that sort of financial flexibility may not be able to actually obtain those drugs. So having an alternative such as medical marijuana might actually be a really great alternative that a lot of people can explore. And some people just don't want to do the hard drugs thing. They prefer to get some CBD, some THC. So it's definitely something that a lot of people find themselves in a tight position when it comes to the 2A rights and trying to exercise your health and make sure that everything is above board.
And so, I mean, that's all very, I know, lawyers telling you,
Yeah.
I don't know.
Right.
I mean, practically, my advice would be, you should think about, I mean, you're essentially choosing between two rights, right? If you're in a place where it's legal to use marijuana,
Yep.
if you want to be safe and you want to be careful, you need to make a choice between your Second Amendment right and this other legal, ability to use marijuana. Because if you put them together, could you potentially lose those Second Amendment rights? Potentially, yes.
Yeah.
So in this situation, you got to basically pick between a 2A right, a right which is enshrined under the Constitution, and your health. Isn't that crazy? Making people pick between a right which is afforded under the Constitution, which may conflict with something. I think that that's absolutely crazy. But let me know what you guys think. And if you guys are getting value from this video, please do like, share, and subscribe. Drop a comment down below. These things help us out a lot. And let's keep it moving.
Yeah.
So, I mean, it's one of those things, we don't have good legal authority yet to break it down. And until we have good legal authority, do you want to be the test case? My answer to that is always no.
Yeah, probably not.
Yeah, so you basically do not want to be the test case or find yourself in that situation. But we do have good news, because there have been a few cases that have come up which have sort of swayed the way this has been leaning. But before we even get into that, a lot of you guys will be familiar with this most recent situation. So let's have a look at this.
Hunter Biden was convicted of lying about his drug use to buy a gun. While Biden acknowledged he was a user of crack cocaine, people on social say this same law could apply to people using marijuana.
Now, real quick, obviously, cannabis and crack cocaine, two completely different things, absolutely different things. So I don't want to get that twisted, but you may be able to see some similarities through how the law is applied in this situation.
But is that true? Let's verify. Our sources are the National Conference of State Legislatures, the Bureau of Alcohol, Tobacco, and Firearms, and the Gun Control Act of 1968. 38 states and D.C. allow either recreational or medical marijuana use under their laws.
Okay, 38
However,
states. I think I said 34 before. 38.
marijuana remains illegal at the federal level. The ATF says until that changes, it remains federally illegal to mix marijuana with firearms and ammunition. The ATF warns gun buyers about this when...
But you can go ahead and get drunk, though, right? You can still purchase drinks, have drinks in your house, have bottles of alcohol in your house. I know that you cannot, if you are in a situation where you do have to discharge your firearm and you are under the influence, you can really get into some serious trouble, but it's just not as restrictive when it comes to the alcohol as it is when it comes to medical marijuana.
filling out paperwork at the time of purchase, and explains that by admitting to using marijuana, you're prohibited from receiving, possessing, or purchasing a firearm. So, yes, it is illegal to own a gun if you use marijuana, even if it's legal in your state or you have a medical marijuana card. The Drug Enforcement Agency is considering reclassifying marijuana as a less dangerous drug, but it would still be illegal, meaning marijuana users would not likely be able to buy a gun. With your Verify, I'm Brandon Lewis.
Well, that goes to show there's a lot of work that still needs to be done, and this video was actually posted 6 months ago, and simply by having a look at the comments on that video, you're able to see that USCCA actually did a recent video explaining that there may be some change in the law, especially how it's applied and how judges interpret it based on recent cases such as Bruin, Rahimi, and a few others that we will go on to discuss.
A federal judge in Oklahoma rules that a law that prevents marijuana users from owning a gun is unconstitutional.
This comes after officers arrested a man and said they smelled marijuana in his vehicle and later found a gun. News on 6's Lex Rodriguez tells us why the case is confusing for some gun shops.
Gun stores like Advanced Combat in Tulsa sell guns by the thousands every year. From the moment a customer walks through the door, the staff are making an important decision, asking themselves if they are comfortable selling the customer a gun. Manager Mark Heffron says that includes the customer's behavior, speech, and even the way they smell.
You know, you can smell alcohol or you smell marijuana. I mean, we've had guys come in and fumigate the whole shop. You know, it just they smell. It's obvious smell, and so we just have the right to tell them no.
Heffron says the ATF provides dealers with guidelines and requires them to make these judgment calls.
I always just tell them honestly. I mean, it's the best policy is just to be straight up and tell you, hey, I just don't want to sell a gun to you today. You know, you smell like weed. Sorry.
To go a step further, Western District of Oklahoma Judge Patrick Wyrick says people who are considered a danger should not be sold a gun. Court documents show this wasn't the case when Jared Harrison was arrested during a traffic stop. He was on his way to work at a medical dispensary in Lawton last May. Officers say they smelled marijuana in the car, searched it, and found a gun. Wyrick says the mere use of marijuana in possession of a firearm is not a constitutionally permissible means of disarming Harrison.
That's a really important point there, guys, because this guy who's not actually actively using, like they did not catch him blazing up a J, he may have had on his possession, but also who worked at a dispo. Now, there are a lot of people who work at medical dispensaries and even recreational dispensaries that may or may not consume. So does that in itself preclude you from owning a firearm? Really interesting point and something to be paying attention to.
Dismissed the case. OK2A founder Don
So it seems that
disarming
this
Harrison,
case
and
was
he dismissed
dismissed.
the case. OK2A founder Don Spencer says this is a win for the Second Amendment, but says it never should have come to this.
No person should be disbarred their firearm or their rights until due process of the Fifth Amendment has taken place, period. That's what makes this even more interesting and impactful from this court ruling.
Spencer says when cases like Harrison's go to court, the violation of the rights has already taken place, and it's only a win for the Second Amendment if an arrest never happens.
We don't look at it as rights going forward. We look at it as rights being restored that should have never been taken away to begin with.
Lex Rodriguez, Oklahoma's own News on 6.
Now that goes to show, guys, it's really a really contentious point, and it's being argued before the courts to this very day. The most recent case, I think, was literally 2024, just last year. So they're always making changes when it comes to this particular issue. A lot of times they play a role in how future cases are decided. The courts will have to look at those cases that were decided in the past and apply those facts and apply those laws and those principles to the present case to determine whether it is distinguishable or whether it should be decided in the same way. So all that said, where are we right now when it comes to this issue?
Now that you have the chess pieces on the board, let's start moving them around. What does this all mean? Now remember that the federal law says that you cannot be an unlawful user of controlled substance, and that the reclassification of cannabis from a Schedule 1 to a 3 does not change the fact that it is in fact still a controlled substance.
Great point. So even if the rescheduling does occur, it is still a controlled substance and it will still affect your rights, especially your 2A rights. So this is something that a lot of people have issues with when it comes to the rescheduling and the proposal to reschedule it from Schedule 1 to Schedule 2 or Schedule 3. The truth is it needs to be descheduled, not rescheduled. It needs to be taken off completely, descheduled, not rescheduled. Let's deschedule, not reschedule. Let's go on.
What this could open up is that there now could be legal use. As with other non-Schedule 1 controlled substances, it is not illegal to use Ambien or oxycodone or whatever else, maybe ketamine, provided that you're doing so lawfully. Simply put, the fact that it is no longer going to be a Schedule 1 means that under federal law, independent of extreme research cases with special permissions, there may now be a federal legal road. Emphasis on may. Lots of details. Will this mean that you can possess a firearm in states that allow recreational use, of which there's presently, I think, about 24? Well, assuming that you follow all applicable laws and therefore you do not trigger the unlawful user wording, maybe. Check your local listings, check with attorneys in your state. This is not legal advice to folks in 50 US states, or at least the 24 that allows recreational use and the many more that allows medical use. Why can't it be specific? Frankly, there's just simply way too much regulation and red tape to clearly see through the mud of regulation and lawsuits. But one thing is clear. This at least opens up the possibility that it can happen, subject to those details. What's my bottom line? I think there will be a legal road, provided that you are following state law, that you will then be in compliance with federal law, and you're going to be good to go. That's what I think is going to happen, but that is not legal advice. That is legal prediction. I mentioned and I teased that there is a legal trap. I've not gotten to it, but here it is. 18 U.S.C. 922 sub G.
Trap?
It shall be unlawful for any person who is an unlawful user of or addicted to any controlled substance. Addicted to. We've only been talking about unlawful user of. That's what everybody's been hung up on, because you cannot be a lawful user under federal law. Will the regulators, will the prosecutors, will the police, will the courts simply pivot from the unlawful user of clause to the addicted to clause? But Tom, I'm not addicted to marijuana. I'm not addicted to cannabis.
Yeah, how do you determine whether someone is addicted? Someone could just say, yo, I'm not addicted. I can stop at any time, you know? But, I mean, there are clear signs with addicts. You can literally see addicts on the side of the road and stuff like that, addicted to hard drugs. But the point is, if someone is just a regular guy and they occasionally use it, does that amount to addiction? Who determines what addiction is? Who defines addiction? Interesting points to consider, guys.
I smoke once a year, once a quarter, once a month, once a week, once a whatever. But I'm fine. I pay my taxes. I'm W-2. I've got kids, maybe. Who knows? Well, the Controlled Substance Act defines an addict as this. The term addict means that any individual who habitually uses any narcotic so as to endanger the public morals, health, safety, or welfare, or who is so far addicted to the use of narcotic drugs as to have lost the power of self-control with reference to this addiction. That's a lot of open-ended language,
Yeah,
folks.
that's a lot of open-ended language. Let's take a pause and look at that closely, because is so far addicted. Let's have a look at this. The term addict means any individual who habitually uses any narcotic drug so as to endanger the public morals, health, safety, or welfare. So if I'm blazing up at home in the privacy of my home, pretty much like I am right now. Well, I'm not actually blazing up right now, but I am in my home right now. If I'm doing something at home in the privacy of my own home, does that endanger the public morals, health, safety, or welfare? Personally, I don't think so. But again, it depends on who is interpreting and applying that law.
Or
let's go on.
Who is so far addicted to the...
So you got to be... the second part of this test is you're so far addicted to the use of narcotic drugs as to have lost the power of self-control with reference to his addiction. So in other words, you have no self-control. The stuff is on the table. You need it now. You need to blaze up now. You just finished blazing up, but you need to blaze up again right away. You know, you lost all self-control. That is something that is pretty subjective, isn't it? Like, I can think I've not lost self-control. Someone else can think I have. Someone who does not partake in the good herb at all could say, yo, this guy, I seen him smoking 2 weeks ago. He's smoking again. That's crazy. He has no self-control. Again, that's a really subjective thing, and it's so open-ended that it can be defined and changed by anyone based on different circumstances, different situations, or how that person and that person themselves perceives the good plant. So let's go on.
Use of narcotic drugs as to have lost the power of self-control with reference to this addiction. That's a lot of open-ended language, folks. Endanger public morals, health, safety, welfare, or lost power of self-control with reference to this addiction. So public intoxication, is that endangering public morals?
Good point. Public intoxication. There are drunk people all the time walking around in the streets. You see them outside clubs. You see them outside parties. You see them everywhere. But does that mean that they lose their 2A rights? Typically, I don't think so. From what I've experienced, a lot of the times they don't. Interesting point.
It might not be in San Francisco, but it might be in Oklahoma City. And on top of the fact that you have different areas that feel differently about drug use, Now we have the same question about how do they feel about guns. And quite often, people who take a left on guns may take a left on drugs, and likewise, right on drugs, right on guns. So how are they going to feel about once we start basically connecting the two? How about the phrase that talks about what is a loss of self-control? Is monthly use per se a loss of self-control? How about weekly use?
Exactly. How much is too much? How can someone determine what's too much? What may be good for me may not be good for you. Very, very interesting things to consider.
Does the frequency of use even have any kind of bearing whatsoever on whether or not you're addicted?
Because you can use frequently or you can use infrequently. You can probably blaze up once a day. Someone may just hit one bowl once a day. Someone may roll up a massive blunt once a day. The amount is different. The frequency and the amount, the amount literally can play a role in this too.
You can see all these questions arising.
All these questions.
Ultimately, if the law is struck down by the
variables.
U.S. Supreme Court in the Daniels case or another case, at least the guardrails might be put up somehow on how we might be getting some clarity to avoid an era of, frankly, quite unequal prosecution across America under this statute. I do predict that the U.S. Supreme Court will, at a minimum, with time, allow laws that prohibit individuals from being under the influence from possessing firearms as being constitutional and legal, since there is at least some history there of states doing just that. Whether the courts disallow individuals who are drug users, perhaps legal ones, but are sober from possessing firearms, that's definitely a major step, and I would say even a leap into something that we have covered in other videos in depth, and we've examined that history. If you want to see more about that, check out our...
There are a lot of variables when it comes to this, but I really want to find out what you guys think. Is this something that affects you guys? Is it something that is on you guys' mind? Is it something that you guys have any opinions on? Drop them down below and let me know. I'm always interested to find out what you guys got to say. There's also a lot of things happening down in Florida when it comes to recreational herb, and to find out more about that and how those can impact things in the future, definitely check out that video because it's coming up right now.